History Month. This session's focus is on Black and Indigenous advocacy and reconciliation. My name's Steve Tierney. I'm a manager and project lead for the Housing and Infrastructure Service Reform Directorate at Indigenous Services Canada. As part of our inclusivity, I'll now describe myself. I'm an Indigenous man, 6 foot tall, have blue eyes, brown beard, wearing a blue dress shirt with a black tie that was gifted to me by an Algonquin friend that has a feather on it. I'm joining you from snowy Ottawa today, which is on a traditional territory of Algonquin Anishinaabe Nation. I'd like to take a moment to also recognize all of the traditional territories from where you are joining. Please take a moment to honor the ancestral grounds where you are joining us from and remind ourselves to respect and nurture our relationship to the land and its first peoples, both past and present.
J'ai l'honneur aujourd'hui de vous souhaiter la bienvenue à ce colloque qui s'inscrit dans le cadre du mois de l'histoire des Noirs. Chaque mois de février, les gens de partout honorent l'héritage des personnes noires au Canada et de leur communauté. Aujourd'hui, Relations couronnes autochtones et Affaires du Nord-Canada, Services aux Autochtones Canada et la Commission de l'immigration et du statut de réfugié du Canada ont collaboré et sont heureux d'accueillir Andrew Leroy Rudder, un avocat noir de dommages corporels. Aujourd'hui, il partagera ses réflexions sur le thème de l'intersection, de l'allié et de la défense des droits en tant que jeune avocat noir travaillant avec les communautés autochtones. Andrew a reçu de nombreux prix pour son travail novateur visant à éliminer les obstacles à l'accès aux soins de santé pour les communautés autochtones. Cet événement peut contenir des renseignements susceptibles de déranger ou de bouleverser certains collègues. Veuillez voir dans le chat pour des ressources qui vous sont disponibles.
This event could be emotional and triggering for some participants. The chat contains available health support services that are available. This event will be recorded, and I'd like to remind you that simultaneous interpretation in English and French is available for this event. Please see the chat for the dial-in numbers for English or French interpretation. Sign language interpretation is also available. We have disabled your microphones, video cameras, and the chat, but please ask your questions using Mentimeter. You can use your phone or computer browser to participate. Type menti.com, menti.com, and our code today is 644312. You can ask your questions at any point during the event, and you can vote on your favorites. We will do our best to answer as many questions as we can after Andrew's presentation.
Et maintenant, laissez-moi vous présenter notre invité. Andrew Leroy Rudder est un avocat spécialisé dans les litiges civils et les préjudices corporels, incluant les chutes, les agressions, les prestations d'invalidité et aussi dans le domaine des déficiences catastrophiques. Andrew is a published author of the LexisNexis Inc. book entitled Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, and the founder of Rudder Law Group Professional Corporation. He blogs and vlogs regularly on the blog entitled Personal Injury Lawyer Tips.
He's also a recent award winner of the 2022 Reisman Award for the Best New Law Firm, recognizing his work to press for change in the legal system. He's also won an advocacy award from the Canadian Association of Black Lawyers in November of 2022. Andrew received an honors Bachelor of Arts degree from York University, majoring in philosophy, and earned his law degree from the University of Windsor. Andrew, thank you for accepting to speak with us today. The floor is yours.
Good afternoon, everyone, and thank you for that introduction, and thank you to everyone in attendance. Thank you to the wonderful organizing committee for their hard work in putting this presentation together for Black History Month. I'm honored to be here today. Before I get started, I will now describe myself. I'm 6 feet tall, muscular build, early middle-aged, light-skinned Black male with dark brown eyes. I have a light stubble beard, clean-shaven head, and I'm wearing a white dress shirt with French cuffs and cufflinks, a blue and yellow patterned tie looped into a Windsor knot, and a blue vest. Next slide, please. In the spirit of CIRNAC's theme this year for Black History Month, Hours to Tell, where you highlight the importance of storytelling and actively listening, I want to share with you my personal story of advocating on behalf of one of my First Nations clients. Next slide, please. I'll discuss my client's case that revealed a legal glitch in the law to negatively impact marginalized groups in Ontario, which was so obscure that even the people responsible for it didn't know it existed. A glitch that nearly cost her up to $1 million in insurance money for much needed medical and rehabilitation treatment. I'll then tell you how it inspired me to dig deep into arcane legalities to come up with a win for my First Nations client, her troubled family, and other catastrophically impaired marginalized groups. I will then reverse engineer my personal story and highlight 2 systemic barriers I faced in my pursuit of social justice for my client. Next slide, please. The 2 systemic barriers I'll explore are 1, the mistrust my First Nations clients and their family had in the institutions that exist off reserve, which were perceived to embody systemic colonial practices and perpetuate systemic discrimination. And 2, systemic discrimination, or the patterns of behavior as well as policies and practices that create or continue disadvantages for a group of people with common characteristics such as race or First Nations identity. I will discuss how these barriers operate on 3 levels. 1, the impact on the lawyer, such as myself, advocating on behalf of my First Nations client, the impact on my First Nations client who is seeking justice as well as medical and rehabilitation treatment. And 3, the impact on the institution I'm advocating against, such as the corporate insurance company or the judicial court system. Next slide, please. A few years ago, I took on my first catastrophic impairment case following a severe motor vehicle accident involving a 17-year-old First Nations girl. She was born in and lived her whole life on the 6 nations of the Grand River Reserve, which is the most populous and demographically the largest First Nations reserve in Canada. It's located along the banks of the Grand River near the city of Brantford in Ontario. It is the only reserve in North America that has representatives of all 6 Haudenosaunee nations living together and unified under the Great Tree of Peace. Next slide, please. My client was a young, gregarious teenage girl who was a loving single mother to a beloved child. She lived in a house with her mother and 2 older sisters. She was an exceptional horse rider who wanted to pursue her chosen career path as a horse trainer. She trained her horse to compete with her in many barrel horse racing exhibitions in Ontario and qualified for the World Barrel Horse Racing Competition in Atlanta, Georgia. However, unfortunately, she experienced a series of tragic events leading up to her severe motor vehicle accident. Next slide, please. About 7 months before her motor vehicle accident, she gave birth to a beautiful baby boy. However, the birth of her son was tragic. After sustaining seizures during birth due to undiagnosed preeclampsia, her baby was deprived of oxygen. The nurses gave her the choice between letting him go or letting him live. They chose life. However, her boy was born flat, blue, and not breathing. The pediatrician was able to resuscitate her son, but with significant brain damage, weak organs, and reliance on a feeding tube. Despite the fact that she was the primary caregiver to a severely disabled child who would need a team to care for him and help satisfy his significant developmental needs, she loved him unconditionally, and he provided my client with a renewed sense of purpose in life. Next slide, please. Then a few months before the motor vehicle accident, she experienced a tremendous tragedy close to home after a younger brother committed suicide. However, through the support from her immediate family and the close-knit community, she was progressing through the natural bereavement process. Next slide, please. Finally, tragedy struck again. Just before she was about to leave for Atlanta to compete in the World Barrel Horse Racing Competition, she was a seatbelted passenger inside of a vehicle being driven by her cousin at a high speed of 100 kilometers an hour in the 6 nations of the Grand River Reserve. The driver lost control of the vehicle and crashed into a tree, which sent my client flying headfirst through the windshield and causing severe head trauma. The Brantford General Hospital was close by, so the paramedics brought her there, where she was admitted as an inpatient. She also sustained multiple fractures to her spine, right elbow and right hand. This prompted the physicians to transfer her to the Hamilton Health Sciences, which is a hospital network comprising 7 unique hospitals. She was admitted as an inpatient to the Hamilton General Hospital, which is a level 1 trauma center. The radiologists who used recognized brain diagnostic technology to conduct neuroimaging tests, which revealed evidence of acute intracranial pathology. Her cousin, who was driving the car, sadly died of a drug overdose several months later. Next slide, please. At the time of this accident, the Ontario government had recently introduced a new automatic catastrophic impairment definition for children. I thought it might be applicable, so I did what any young lawyer would do. I took a deep dive approach to discovering the answers to the questions I sought. I completed a comprehensive review of my client's entire medical file and researched the medical literature on traumatic brain injuries in children. I searched for legal precedents that extended the application of the criteria of the new catastrophic impairment definition to cases, but to no avail because the law was so new. However, I believed very deeply that my client satisfied the 3 criteria. Next slide, please. In order for my 17-year-old client to be granted the automatic catastrophic impairment designation, she had to satisfy 3 criteria. 1, inpatient admission to a public hospital in the guideline. 2, positive findings of intracranial pathology. And 3, the use of medically recognized brain diagnostic technology. Next slide, please. I initially assumed my client satisfied all of the 3 criteria. So I got a medical opinion from a pediatric neuropsychologist with a PhD who agreed with me. The doctor completed an OCF-19 application for determination of catastrophic impairment form and sent it to my client's insurer. The insurer retained a reputable neurologist who also concluded that my client met all of the 3 criteria. So case closed, right? Well, no, not so fast. Next slide, please. If you take a closer look at the first criterion to be satisfied, it states, quote, admission on an inpatient basis to a public hospital in a guideline, end quote. Well, this begs the question, what guideline? The guideline that's being referred to is the June 2016 Catastrophic Impairment Public Hospitals Guideline, Superintendent of Financial Services Guideline number 0116. Next slide, please. The superintendent's guideline has a list of the 12 public hospitals for which inpatient admittance is the first criteria for determining whether an insured child has a traumatic brain injury and a catastrophic impairment. You can see the 12 hospitals in this slide and which city they're located in. These hospitals are on the guidelines list because a medical expert panel retained by the Minister of Finance concluded that admission of a child as an inpatient to them is a sensitive indicator, objective marker, and a clinical predictor of prolonged recovery and poor outcome. Next slide, please. The superintendent's guideline list of 12 public hospitals was taken from the 11 hospitals that the Ministry of Health and Long-Term Care designated as lead trauma hospitals in the early 1990s, which you can see here in this slide. Next slide, please. If you compare the 2 lists, you'll notice that the Hamilton Health Sciences in the chart on the right side was removed and replaced with the Regional Rehabilitation Center and the McMaster Children's Hospital in the chart on the left side. The Hamilton General Hospital is not on the guidelines list of public hospitals. Next slide. Since my client sustained multiple fractures, in addition to suffering a severe traumatic brain injury, she was first admitted as an inpatient to the 6th South Surgical Trauma Unit within the Hamilton General Hospital because she required immediate orthopedic surgery, which took priority over her head trauma. One of the 2 Hamilton hospitals that was on the guidelines list was, again, the Regional Rehabilitation Center. The Hamilton General Hospital and the Regional Rehabilitation Center are within the same hospital network, Hamilton Health Sciences, and are literally connected to each other by a bridge. Since my First Nations client's spinal surgery was a priority at the moment, she was admitted as an inpatient on the wrong side of the bridge. The failure to include the Hamilton General Hospital in the guidelines was a bureaucratic glitch, which was going to cost my First Nations clients hundreds of thousands of dollars in much needed medical and rehabilitation treatment, care services, and support. Next slide, please. So the insurer denied my client the catastrophic impairment designation. My client's mother, who was a single mother of 3 children, was devastated. A few years before the motor vehicle accident, her other daughter was on a 4-wheeler and was hit by a car. Her injuries linger. My client's mother didn't know what she was going to do and how she was going to pay for the exorbitant expenses of treatment, care services, and support for her teenage daughter. My client left the Hamilton General Hospital with severe pain in her back and debilitating depression. She had uncontrollable emotional outbursts. She needed mental health care, physiotherapy, and pain management. She could not take care of herself, let alone take care of her 16-month-old son, who has a feeding tube and needs constant care. My client's mother didn't have time to unravel the bureaucratic knot that was going to cost her struggling family up to $1 million in insurance money. She was too busy caring for her catastrophically impaired daughter and a severely disabled grandson while running the corner store she owns on the 6 Nations of the Grand River Reserve. The insurer's decision, in my opinion, violated the legal principle of good faith dealing with vulnerable victims. Next slide, please. When there's a vulnerable, marginalized group being denied justice of an imbalance of power with a large corporation or the government, that pulls my heartstrings. This injustice made no sense to me, and I couldn't sleep at night. So I took a deep dive into the evolutionary changes of the catastrophic impairment definition from 1996 to 2016, in order to better understand the government's underlying rationale for creating a new catastrophic impairment definition for children. I undertook a modern approach to statutory interpretation to show that it did not harmoniously coincide with the main objectives of insurance law, the purpose of insurance contracts, the scheme of the Remedial and Benefits Conferring Insurance Act, and the relevant regulation and intention of the Ontario legislature within the broader context of the evolutionary changes in the definition of catastrophic impairment. I presented the insurer with a sound, comprehensive argument, and they eventually overturned their denial and granted my client the catastrophic impairment designation. The designation increased my client's accident benefits policy limits from $65,000 to $1 million. Next slide, please. I was happy with the result for my client and her family, but I wanted to do more when I began to realize that the provincial bureaucratic glitch also adversely affected other children who live in rural communities and remote areas far away from the guidelines list of 12 hospitals. I concluded that the guidelines interpretation of the new law had discriminatory ramifications based on geographic location, which had to be changed. I was reminded as a lawyer, oral advocacy transcends beyond the legal retainer of a client and extends out to the larger community and social justice issues. One decision for my First Nations client impacts the life of one child and her family. If, however, I was to change the law, then that would impact the lives of thousands of children and their families within the entire province of Ontario. I first started raising awareness by telling as many personal injury law lawyers about what I uncovered, and then by writing a 6-part series on the social justice issue, which was published in the Lawyers Daily. I obtained the support of the Ontario Trial Lawyers Association. I raised more awareness after social justice columnist Susan Claremont featured the issue on the front page of the Hamilton Spectator newspaper on July 16, 2019, in an article entitled "Injured Girl Denied Insurance Claim Due to Province's Bureaucratic Glitch." It had quotes from myself, my client's mother, representatives from the Hamilton Health Sciences, and provincial government bodies such as the Insurance Bureau of Canada, the Ministry of Health, and the Ministry of Government and Consumer Services. A representative from the Ministry of Health, who was shockingly unaware that the Hamilton General Hospital was a level 1 trauma center, asked the Spec newspaper to give him proof that it was. It was shocking because the Ministry of Health designates and funds Ontario's level 1 trauma centers. The former Ontario New Democratic Party leader, Andrea Horwath, who embraced my solution for the changes that need to be made to the insurance law, was also quoted as saying the following, quote, "The insurance system is a racket in our province. Depending on where you live, you have different access and you have discriminatory variables that affect you, including if you don't live anywhere near one of the 12 designated trauma centers, then you're out of luck. And if you do happen to live near what is considered a major trauma center and the insurance industry has decided that they don't consider it one, then you're out of luck. And so what we need to do is actually fix the insurance system to get rid of these inconsistencies and the inequality that's built into the model that really just helps insurance companies to not pay out the benefits that families need," end quote. There was also a quote from Ontario's Financial Services Regulatory Authority, Ontario, which is a self-funding Crown agency which acts as the financial regulator for Ontario. It administers and regulates the insurance sector and enforces the Insurance Act. Their senior communications officer told the Spec newspaper that they weren't going to amend the guideline at the time. So after the article was published, I decided to take matters into my own hands and reach out to them myself. I eventually met with their senior manager on policy interpretation, as well as their senior in-house counsel. I persuaded them to amend the superintendent's guideline number 0116. Next slide, please. Effective October 17, 2020, the old guideline was replaced by the new Guideline on Public Hospitals and Determination of Catastrophic Impairment. They included all level 1 trauma centers in Ontario, including the Hamilton General Hospital, further to the lead trauma hospitals accredited by the Critical Care Services of Ontario. Next slide, please. The change is a great first step, but it doesn't go far enough to eliminate the discriminatory ramifications based on geography. Further to the Government of Canada stats, Ontario is home to 23% of all Indigenous peoples in Canada. There are 133 First Nations communities located across Ontario, representing at least 7 major cultural and linguistic groups. 5 of the 20 largest bands in Canada are located in Ontario, with Mohawks of 6 nations being the largest. Over 30 First Nations in Ontario are considered remote, accessible only by air year-round or ice road for much of the year. There are more remote First Nations in Ontario than any other region in the country. More needs to be done to protect marginalized groups. Next slide, please. If you want to learn more about my proposed solution, then please feel free to read my book, Catastrophic Impairment Law in Canada. Next slide, please. I now want to reverse engineer my case and discuss how the two systemic barriers I faced while advocating on behalf of my First Nations client operate on the following three levels. Again, 1, the impact on the lawyer, 2, the impact on my First Nations client, and 3, the impact on the institutions. Next slide, please. The first barrier I want to discuss is the lack of trust that my First Nations client and her family had in the institutions, including people operating in them that existed off reserve. Next slide, please. As a Black lawyer, a member of an equity-seeking group, I naively thought that I would be viewed by my First Nations client and her family differently. I thought this because even though there are many differences in how Black Canadians and First Nations people experience the negative impact of systemic racism in Canada, there are similarities. However, I learned early on that my First Nations client and her family, in particular her mother, initially saw me as a lawyer who was a part of and therefore influenced by the same system that they didn't trust. Initially, my client's mother would not allow me to speak to or meet with her daughter alone for a long period of time. It literally took me a little over a year to earn the trust of my First Nations client's mother. Next slide, please. I began to understand that the mistrust is rooted in colonialism, where the political agenda of the Canadian government's 20th century colonial system was to assimilate and acculturate First Nations peoples into the dominant culture. This agenda was evident in the impact on First Nations people relationship with the environment following their dispossession of and displacement from traditional lands in the 20th century. This agenda was also evident in legislation, such as the Indian Act, which was first introduced in 1876 and subsumed a number of colonial laws that aimed to eliminate First Nations culture in favor of assimilation into Euro-Canadian society. One of the most powerful mechanisms of assimilation was the Canadian government's use of residential schools, where culture, language, family ties, and community networks were destroyed for generations of First Nations peoples. In an article entitled Health Inequalities and Social Determinants of Aboriginal People's Health, the authors wrote the following, quote, "One major dimension of historical trauma is the experience that Aboriginal students went through in attending residential schools, an experience that still has ramifications today for the health and well-being, not only of the survivors, but also their children and grandchildren." Next, end quote. One of my First Nations clients has a grandmother who attended the Mohawk Institute, which was a residential school located in Brantford, Ontario. It was run by the Anglican Church of Canada and the Government of Canada from 1828 to 1970. Between 90 and 200 children were forced to attend the school each year, some of whom are connected to my First Nations clients, who can attest to the negative impact that the residential school experience and the missing girls has had on their parents and grandparents and themselves. My First Nations clients also have mentioned to me what is known as the 60s scoop, which refers to the mass removal of First Nations children from their homes and families, in most cases without the consent of their families or bands, and then placed into the child welfare system to reside primarily of middle-class Euro-Canadian families, even though it doesn't refer to an explicit government policy due to the drastic overrepresentation of First Nations children in the child welfare systems in the 1960s. Many believe, including most of my First Nations clients, that the child welfare system replaced the residential school system. The drastic overrepresentation still exists today, as for example, according to Census 2021 data, quote, "In Canada, 53.8% of children in foster care are Indigenous, but account for only 7.7% of the child population," end quote. Intergenerational trauma is a real thing. Coping and adaptation patterns develop in response to traumatic experiences are learned from or otherwise impact subsequent generations living with survivors, which in turn are handed down to future generations. My First Nations client, who is suffering from severe social anxiety, often declined suggestions for support, whether that be personal support workers or medical transport. She wasn't open to strangers in the home and did not waver from that decision despite many conversations. She also feared how outsiders would judge the way she was raising her child, and that they might involve child welfare services. This created a barrier to her receiving help. When I started to learn more about the missing and murdered Indigenous women and girls, I began to understand even more why my First Nations client's mother was more vigilant about protecting her daughter. Next slide, please. I overcame this barrier by continually reminding myself that the cornerstone of working with First Nations people is building a relationship of trust over time and mutual transparency. I earned my client's mother's trust through my consistent actions, not my words. For example, after the initial motor vehicle accident, I visited my client and her mother at the hospital in the intensive care unit at the Hamilton General Hospital and helped them with their interactions with the doctors and the hospital staff. I later visited them at their home on reserve several times, which is 55 minutes away from my office. While I was at their residence, I sought first to understand before being understood by actively listening to my client's unique story, which allowed us to slowly create more inclusive opportunities to work together. I also got to know her immediate family as well in order to better understand my client and find even more inspiration to fight for her. This also enabled me to slowly eliminate the preconceived notions I realized I had of First Nations people too, which in and of itself constitutes a barrier. Next slide, please. My First Nations client and her mother did not only distrust the institutions that existed off reserve, such as the healthcare system, but also the people who worked in it, such as the occupational therapists who initially visited them. They were highly qualified, but had no experience working with First Nations people on reserve. They didn't have a full appreciation of the non-insured health benefits for First Nations people. They became frustrated when my First Nations client canceled appointments or was a no-show at an appointment with a specialist. They interpreted the non-attendance as non-compliance and a lack of interest in wanting to get better. The insurance company adopted the same belief, partly due to how these occupational therapists reported back to them. So my client's family began to view the occupational therapist as an extension of the healthcare system that they didn't trust. Many occupational therapists requested to be replaced. I replaced about 8 to 10 occupational therapists on this file. Next slide, please. One of the sources of mistrust came from some of their past experiences as patients being exposed to disrespect from healthcare professionals through tone and body language, as well as experiencing overt racism and being neglected or not taken seriously. Again, prior to my First Nations client's accident, she gave birth to a baby boy with significant developmental needs in relation to the brain damage he sustained following consequential hypoxic ischemic encephalopathy during birth. When unfortunate incidents like this happen, on top of the systemic racism they experience, it increases the mistrust they have of the healthcare system. My First Nations client and her mother didn't know that they could pursue a medical malpractice lawsuit to gain some justice for what happened to her son, until I told them about their legal right to do so just in time prior to the 2-year statute of limitations period. Next slide, please. One of the barriers that First Nations people on reserve face while trying to access healthcare services is a limited number of doctors available. One of my First Nations clients who lost her son in a fatal car crash was diagnosed with a prolonged grief disorder, post-traumatic stress disorder, and panic disorder that continued to affect her functioning in multiple domains. She was seeing the only clinical psychologist on reserve who created a culturally competent healthcare environment. Unfortunately, the doctor recently announced her retirement, which now leaves my First Nations clients access to a new clinical psychologist in limbo. The inability to afford the transportation costs is another barrier. My teenage First Nations client had access to Six Nations transportation, but unfortunately this service is inconsistent as it runs based mainly on volunteers. Alternatively, she can access Indian Affairs transport, which requires a doctor's note, as well as my client's engagement and consent. This was problematic in my case because my client preferred transportation from a trusted family member, like her mother, who would also attend the appointment with her and not just drop her off. Next slide, please. I overcame this barrier by finding a First Nations occupational therapist from the Six Nations of the Grand River Reserve. She was able to create a culturally competent healthcare environment where my First Nations client and her family felt culturally safe and were treated with respect, compassion, and cultural understanding. She understood the unique barriers First Nations persons face to accessing healthcare than others in Canada and their roots, and aided my client in breaking down these barriers throughout her practice. However, I learned that I cannot assume that all First Nations people prefer First Nations occupational therapists, home care workers, or same community workers, due to the fears that confidentiality cannot be maintained. The way one of my First Nations clients have previously said this is, quote, everyone in town knows one another and everyone talks, end quote. So I would reiterate that there are occupational therapists or workers which can be coordinated of First Nations ancestry, or if they prefer an outside provider, then that could be arranged too. Next slide, please. The lack of attendance by my client to scheduled appointments further to the treatment plans paid for by the insurers resulted in the insurer denying some future treatment plans. This caused delays from me having to appeal the insurer's denials to Ontario's Licensed Appeal Tribunal. It also impacted how the insurer quantified my client's settlement because they heavily rely on what's called a burn rate, where they rely on the rate at which benefits were paid to the insurer in the past to predict the approximate amount of benefits that would likely be paid in the future. This acted as a barrier to negotiating a proper settlement to secure my First Nations client's future. Plus, the lack of supporting documentary medical evidence initially weakened my ability to advocate on her behalf at the Superior Court of Justice in regards to her tort lawsuit. Next slide, please. I overcame this barrier by, again, finding a First Nations occupational therapist who aided my client in attending all of her medical appointments. Next slide, please. The second barrier I want to discuss is systemic discrimination. Next slide, please. As a Black lawyer advocating on behalf of First Nations people, I've experienced the impact of systemic racism that is rooted in Canadian history, which reinforces attitudes, beliefs, prejudice, stereotyping, and discrimination towards people of Black descent. For example, I could remember attending an examination for discovery where a senior Black female lawyer sized me up, looked at the court reporter, and then asked, "Has Mr. Rudder arrived yet?" I was wearing a suit and had my materials on the table. I stood up and calmly replied, "Yes." I then extended my hand out to shake her hand and then said, "It's a pleasure to make your acquaintance. I'm Mr. Rudder." The senior lawyer was shocked and felt embarrassed for making the presumption. This is an example of the influential power that systemic racism has, even on Black people operating within the institution that perpetuates it, where it even influences their own preconceived notions of what a lawyer looks like. This is an example of implicit racial bias, which refers to unconscious mental processes that lead to unrecognized negative feelings and judgments towards specific people based on their racial identity. It shapes people's conduct of behavior, attitudes, and beliefs, and ultimately their behavior and decision-making toward another person, which in the legal world creates barriers. Next slide, please. The way I dealt with this in my case was by making sure I stayed educated on the legal jurisprudence, precedents, and everything that I needed to know about my legal profession in order to continue to remain strong. I chose not to be intimidated by other individuals that might be older than me, feel like they are more experienced than me, or feel less of me because of their implicit racial bias towards me. I convinced myself every day as I fought for my First Nations clients' rights that I was capable of doing just as much good work as the legal team representing the insurance company. I got to a point where I was no longer concerned about their behavior toward me because of their racial bias. Rather, I focused on my behavior in response to it. The more I excelled and conducted myself in a manner that surpassed the limited box that their implicit racial bias tried to keep me in, the more I educated them through my actions by influencing their perception of what a person of color can accomplish. Next slide, please. In my case, we saw that the legislatures who drafted the law did not openly say that they intended for it to create disadvantages for a particular marginalized group. However, the true systemic discriminatory nature of the guideline was manifested in its effect in terms of how it negatively impacted marginalized groups in rural and remote areas in a disproportionate way in comparison to other groups in society. Next slide, please. I overcame this barrier by speaking truth to power. I let Ontario's Financial Services Regulatory Authority know that they must do a better job committing to meaningful consultation of First Nations people and carefully consider the potential impact on them. Next slide, please. In my case, where systemic discrimination went unchecked, the insurance company continued to exploit the bureaucratic glitch in the law to serve their self-interest. What's so concerning is that the amendments to the catastrophic impairment criteria took effect on June 1st, 2016. I discovered the discriminatory ramifications in 2019, so it went unnoticed for approximately 3 years. There is no way of knowing the countless numbers of children who were deprived of a catastrophic impairment designation absent the insurance companies coming forward and providing that data. Next slide, please. I overcame this barrier by speaking about what was right and told the people in charge what's what on a pro bono basis, because I understood that my duty as a lawyer extended beyond a mere retainer of a client and to the larger community. Because as the late Martin Luther King Jr. once said, quote, "Injustice anywhere is a threat to justice everywhere. We are caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly." End quote. Next slide, please. The truth of laws like the one in my case need to be revealed to the people and institutions in charge so they can be challenged, as well as shared with the public at large in order to bring about effective change. I say share with the public because in my case, I didn't gain real traction with politicians and the government until I started to raise public awareness by getting the media and lawyer associations involved. When the constituency of the politicians were made aware of the issue, they began to take notice, and the hospitals and government took notice too. I leveraged that to initiate change. True reconciliation doesn't just embody an apology and commemoration that acknowledges and redresses past harms, but it's also a lifelong process of healing of relationships that requires continual public truth sharing. This is challenging when marginalized groups such as my First Nations client face systemic barriers that get in the way of lawyers advocating on their behalf and feel voiceless and underrepresented at the table where important decisions are being made that impact their lives. So it's important for all of us to use our platforms to be their voice in advancing the public truth sharing component of reconciliation in the courtroom via lawyers like myself, Parliament via our elected officials, the Canadian government via national government departments such as CIRNAC, IRC, and IRBC, even if it means pro bono work, in order to give them the access to justice they deserve. It's also incumbent on institutions to help advance reconciliation by, amongst other things, promoting equity, diversity, and inclusion in the workforce, as well as participate in multi-day reconciliation action plan discussions and anti-racism task forces, and implement EDI plans and policies. The institution should be required to understand and account for First Nations insured background and history, and the systemic discrimination and the socioeconomic marginalization First Nations people in Canada experience. True reconciliation requires First Nations people to have a seat at the table where important decisions are being made that impact their lives. Also, when laws like the one I dealt with in my case manifest systemic discrimination, it is important for the institutions involved to reverse engineer the issue, understand where they went wrong, and figure out how to implement changes to ensure that this doesn't happen again, and then reassure the public about same, especially the marginalized group that was adversely affected by it. Reconciliation doesn't call for whispered truths, but loud truths. Next slide, please. Thank you, everyone. If anyone wants to contact me to continue the discourse after this presentation, please feel free to reach out to me via email at andrew@rudderlawgroup.ca. And with that, I'll be more than happy to answer any questions that you may have. Thank you.
Thank you very much for sharing your lived experiences, your work, and for your gripping and inspirational stories, Andrew. We'll now turn to some questions and answers. If there's any questions in the chat that we're unable to get to today, Andrew has kindly offered to provide written responses to them, and they'll be made available by emailing the Visible Minority Employee Network at vmen@rcanc-cirnac.gc.ca.
So maybe I'll ask a question while we're waiting for questions to pop into the Mentimeter. Andrew, thank you once again. As you know, the people who are in attendance today work to make a real difference in the lives of marginalized, vulnerable, and underserviced people. So through your talk, you had some advice for us in terms of what would you provide as advice on the ways that we can help break down the culture cultural and systemic barriers and help bridge the socioeconomic gaps that you've seen in communities that you work with. So, what would be your advice to all of us in attendance here today?
Thank you so much, Chantel, for that question. I think that regardless of whether you're in a position of privilege or a position of authority, with power, or whether you are part of a marginalized group such as myself, who's in a position of influence, I think we could all engage in allyship on behalf of marginalized and underserved people. I think that we could all use our platform to make a change by being purposeful and action focused. I think it's important that you don't make assumptions about whether the inclusive strategies you've implemented, for example, in your federal government departments like CIRNAC, for example, are making a difference. You have to use EDI data to verify this, and you have to embed EDI data in your processes and actively use it for decision making and measuring progress. I think you also have to carefully analyze both the individual and the collective effect of the policies and the practices within your government department at all levels in order to see if they create disadvantages for marginalized groups, as well as whether they both mirror or reinforce those beliefs, attitudes, stereotyping, discrimination, prejudice, etc., towards marginalized groups. I think you also have to respectfully, call out inappropriate behavior against marginalized individuals amongst peers and yourself. Call a spade a spade. You have to actively intervene. Don't remain quiet. Remember, inaction in terms of a failure to call out inappropriate racist behavior or challenging forms of systemic discrimination within the workforce when you see it could be just as bad as participating in the perpetuation of those acts, because you're implicitly subcommunicating that it's acceptable. Challenge promotion hiring decisions. Embed inclusion in your company values, language, and in your progression tracks. Right? Inclusion isn't something that just sits at the side. It's intertwined into the very being of your company. And I would say actively listen to the stories of marginalized individuals and believe their experience. Don't get defensive, right? Remember that your experience isn't the only one. I've done various things on my part at different stages. I like to volunteer my time. I like to help the next generation of lawyers, helping out law students in various mentorship programs. Just last week, I met with a young Black lawyer who's thinking of starting his own practice. And I sat down with him and helped him figure out how to get started, how to build his law firm from the ground up. Pursuing social justice issues. When I went to change the law, that I did that on a pro bono basis. All right. So, yeah.
Thank you, Andrew. Some Menti.com questions have been coming in, so I'll read you your next question. You learned a lot about your clients and their culture and challenges. What do you feel they learned about you as a Black man and your challenges?
Thank you for that question. It's a really important question. Like I said in my presentation, it took me a little over a year to earn the trust of my client's mother, which I totally understand to this day. And she learned from me that, not all lawyers that she deals with, are bad. Not all lawyers that she deals with, don't have her best interests at heart. I make myself accessible to my client 24/7. It's something that I've adopted with all of my clients after I started my own law firm. And when she tries to call me at 9 o'clock at night and I respond, she appreciates that. Sometimes when she sends me a text message at 3 o'clock in the morning and I respond, she appreciates that as well. She's learned that I also have challenges of my own, which was enlightening for her. She didn't see that other side of it, right? Like I said in my presentation, she initially saw me as a lawyer, but as we got to sit down at her residence and I got to, share tea with her and her family and sit down around the dining table and talk, she started to learn about my vulnerabilities as well and some of the challenges I have to face. And she began to respect me more, and that actually helped facilitate the relationship we were building based on trust and also transparency. I wasn't hiding anything. I was disclosing some of the challenges I faced, and she respected me a lot more because of that.
Great. Thank you so much for that answer. And we do have another question here that I'll read. How have you managed the emotions around these very difficult cases, yours and your clients? And that's such a great question. So
Yeah,
thank you
thank
for
you.
it.
Yeah, no, thank you. That's an excellent question. Funny thing is, I was visiting my mother, my parents over the weekend, and they asked me this exact same question. The challenges I face with my clients are tough. What gets me through it is knowing that if I don't do it, how much more difficult their lives are going to be. I did that when I stepped out to change the law. I didn't see anybody willing to step up to do anything. And if I don't step up and take on that challenge, like I said, how many other children are going to be adversely affected by that guideline that had discriminatory ramifications? So that kind of helps me get through it. I also, something I also say as well is, the insurance companies, a lot of them, they view my clients as a claim number or a policy number, and that's a way to detach from them, to not see the humanity. All right, I view my clients as human beings. All right, some of my associates say, well, it's not a good idea. You have to be able to draw a line. But for me, I have a different view. Like I said, getting to know my client and her family and the struggles that they go through, and also the background, right? Like the tragedies that my client went through is important for me to know as well, because that's contextual. That gives context to everything else, and it gives me more motivation to fight for them. It gives me more motivation to fight hard for them. So I don't believe in establishing that line and maybe not getting too close to the clients. I feel like you have to.
Thank you, Andrew. I couldn't agree more. If you don't understand the people you're trying to help and open yourself up to them, it's very difficult to affect the change that you are doing. So thank you. Another question that's come in as well. Our audience is thanking you for your excellent presentation. In part of your work, are you also working with Indigenous lawyers when working with Indigenous communities or Indigenous clients?
No, no, I'm not. I would like to do that more. Unfortunately, I'm just not aware of any Indigenous lawyers who do the kind of work that I do. I'm open to, reaching out to them if they're out there and working alongside them. Like I said, I've been fortunate enough to find some First Nation healthcare workers who are from the reserve, who help me in terms of being culturally sensitive when I begin to represent a new client who's from the Six Nation, the Grand River Reserve. But yeah, like I said, I would really like to meet more Indigenous lawyers, especially in this area around where I live, and work together with them. I think it'll be great to pool our resources together and be a much more, stronger force in advocating for Indigenous people.
Thank you so much for that answer, Andrew. I think it's very inspirational to hear you talk about the advocacy of yourself, but of also the colleagues that you're working with, and that's a true allyship. So we have another question, and they're thanking you as well. So thank you very much, Andrew. You are truly inspiring me. The question is, how can we ensure effective participation of Indigenous peoples in decision-making regarding policies, programs, and projects affecting them?
Thank you for that question. I think that, first and foremost, when you're thinking of allyship, it's important for everyone to remember that it's not just about speaking for those who do not have as loud of a voice as people with privilege, but it's more rather about using your voice to give those people their own platform to speak and empower themselves, and ensuring that they have a seat at the table where decisions are made that impact their lives. I think the way that you do it is, again, ensuring that, more Indigenous people get opportunities within the institutions, qualified Indigenous people get all the opportunities in the institutions higher up. And if they can't, that the people who are at the table creating those practices, developing those policies, putting together those programs, carefully consider the impact of their decisions on Indigenous people. and consult with others in doing that. Again, it goes back to implementing proper EDI strategies to ensure more inclusion of Indigenous people within these institutions. It ensures once we get them there to ensure that they get the much deserved promotions to go up that corporate ladder as well.
Thank you, Andrew. This question is in French, and maybe I could ask Chantal if she could translate it after I read the question to Andrew. Si vous décidez coucher des étudiants en droit qui seraient intéressés à représenter des clients autochtones, à partir de votre expérience, quels conseils leur donnerez-vous pour bien se préparer?
So the question, Andrew, is if you wanted to coach students in law that would be interested, obviously, to represent Indigenous clients, from your experiences, what advice would you give them to prepare themselves?
Well, first, you want to go to the reserve. I mean, that's what I did. Like I said in my presentation, I always seek to understand before being understood. So when I went onto the reserve, the one thing that I made sure I didn't do was to maintain any assumptions that I had going in. I mentioned in my presentation about a lawyer having preconceived notions going in to represent, in my case, First Nations individual, and how that could be a barrier in and of itself. So one of the things that you have to do, and what I taught myself do, is challenging my own biases and eliminating my assumptions. For example, I do not assume that all Indigenous people will connect with or believe in cultural ideas or practices, right? They might be without cultural teachings, language, or may have been brought up in different faiths. Again, in my presentation, I learned that I cannot assume that all First Nations people refer First Nations occupational therapists, because for some of them, there's legitimate fears of that confidentiality won't be maintained, right? The whole idea everyone in the town knows one another and everyone talks. So you really have to go in there with an open mind, knowing that you don't know a lot, and you have to be willing to, like the theme of this presentation, actively listen to their stories, actively listen to the systemic barriers that they have to face. Do your own education too, like educate yourself, rather, I mean. Learn about some of the reasons, like I said in my presentation, that there's this mistrust, and patience. For me, I knew I was going to earn the trust of my client's mother overnight. This for me was, I was willing to take as long as it would take for me to understand her culture, earn her trust in order to fight for her, because I was just so moved by her story and her family story and her daughter's story, right?
So thank you very much for that answer that really identifies the trust that underlies, I think, everything that we're trying to do. I've one final question for you.
Sure.
Leaving this conference today, if you had one thing that you would ask all of us here to do, what would that be?
Thank you for that question, Chantel. I just say to remember again, at allyship, it's a consistent, action-oriented, lifelong process of building relationships based on trust, consistency, transparency, and accountability rather, of marginalized individuals. Where you don't necessarily have to be a person in a position of either authority or power or privilege to actively support and operate in solidarity with a marginalized individual or group. You can also be a marginalized individual like myself in a position of influence to do that as well. My point is that regardless of your position, everyone can contribute to allyship in some form or another. And the collective efforts of everyone will, I truly believe, over time, have a tremendous impact. I know Martin Luther King, the late Martin Luther King, reminded us that the arc of the moral universe is long, but it bends towards justice. In other words, for me, change takes a long time, but it does happen. I also want everyone to remember that allyship, it's action focused. It's not performative. It's proactive, not reactive. It's purposeful, not aimless. It's continuous, not ephemeral. Lastly, I'll just leave you with this. I believe allyship is also, it's an opportunity. It's an opportunity for all of us to grow and learn more about ourselves while building confidence in and forging long-lasting relationships with others too.
Thank you so much. So that was the last question for you. Alors, ceci met un terme à notre session aujourd'hui. Au nom de tout le monde présent, j'aimerais tellement vous remercier, Andrew, pour votre ouverture, votre générosité à partager, vos conseils et votre passion. C'est par des activités comme celle-ci qu'on apprend, qu'on grandit et qu'on s'ouvre aux autres.
Thank you very much, Andrew, for this engaging, inspiring conversation today. Thank you to everyone who has joined us today, and thank you to the organizers. Andrew, are there any last words that you'd like to end us with?
No, just thank you so much for everyone coming to attend this presentation, actively listening, learning how we could all make changes in our lives for the better. And thank you to this wonderful organizing committee for inviting me here. It was an absolute pleasure to be here. I look forward to working with these 3 government departments in the future and how we can implement the necessary change we need to for the better of marginalized groups across the country.
Thank you, everyone, for participating, and please take care of yourselves. Bye-bye. Miigwech.